Oh, hello, everyone. I'm Jorge Molina, your immigration attorney. And today I have the great pleasure of speaking about a subject matter that I really appreciate and enjoy. We also have a lot of information and sort of breaking news regarding a decision we got yesterday. So we'll be talking about prosecutorial discretion in 2021 and in the immigration world, right? So we have a lot of information. We've saved some time for some questions we received in the past, and for any that you would like to ask here live with us. So, be as always, I'd like to caveat that this is the information provided to you is um, is good to until today, right? So this is subject to change, and very likely we'll be receiving a new memorandum regarding prosecutorial discretion based on the decision we received yesterday from the Attorney General. So I prepare a presentation for you. So let me start that right now. Just bear with me. All right, let me go back. Actually, right here. All right, folks. So today we're going to be defining what is prosecutorial discretion, right? This nebulous term, but I'd like to define it so we can better understand it and understand what it does and what it doesn't do and what it means, right? Then we're going to talk about the current administration's priorities for removal and for initiating proceedings, so which would help us understand what is possible with prosecutorial discretion. And then we'll talk about what actually we can do with this and what are the things that we can request ICE or DHS to do. And finally, like I mentioned a few minutes ago, we have a brand new decision issued yesterday by the Attorney General, and which is related to the subject of prosecutorial discretion. And it was great news for many of our clients and likely many of individuals watching today. And finally, we'll save some time for questions. All right, folks. So what is prosecutorial discretion? Prosecutorial discretion is the ability or the use of judgment by a law enforcement agency. In our context is DHS, the Department of Homeland Security, through its office that prosecutes cases in immigration court. The office is the principal legal advisor. And what prosecutorial discretion is that agencies' use of its own judgment to decide whether or how they would like to enforce the law against someone, or to decide not to enforce the law against someone at all. Now, why does prosecutorial discretion exist? Well, this is a very old tool used by all law enforcement agencies. Now, when you think about it, there's so many cases to prosecute and so many people go after, and there's limited resources, right? So you can't really enforce the law unless you have certain list of priorities and certain set of principles that you're focusing on. So when I say that this is a subject that I really enjoy and like, it is because we're returning to a sense of justice. Based on memorandums issued by the Department of Homeland Security, we know that the department is focused again in the pursuit of justice. It means that ICE attorneys are not just focusing in deporting anyone they can as fast as they can, but that they would like to see justice done in most of their cases. And here's a nice abstract that summarizes that idea and concept. And it reads as follows: immigration enforcement obligations do not consist only of initiating and conducting prompt proceedings that lead to removals at any cost. Rather, as has been said, the government wins when justice is done. So the understanding here is that, perhaps technically in some of these cases, the government doesn't win because there's not a removal order. In the long run, they win because justice has been done and some other major injury was avoided. So, that is what prosecutorial discretion is and the spirit behind it in this current administration. Okay, so we're going to talk about priority so we can understand how prosecutorial discretion is being utilized. So the Biden administration announced 3 priorities for removal and prosecution. So first, people who present a threat to national security. So here, think of people involved in terrorism, espionage, or other threats to national security. So if individuals are selling national secrets or working in a university in a top level collaboration with the U.S. government and they're trading or secrets, that would be considered a threat to national security. So that's priority number 1. Here we have a photo of Al-Qaeda. So think of, terrorists as being priority number 1. Priority number 2 are non-citizens that were apprehended at the border trying to enter it unlawfully on or after November 1st, 2020. So this goes back to border security, right? So we have an administration that has given priority to securing the border, and they want to dissuade individuals from coming to the United States illegally. So the way that they're doing that is that they're making individuals that have just recently entered the United States, and by recent we mean November 1st, 2020, or after November 1st, 2020, and making them a priority for removal. And category number 3 are those individuals who present a threat to public safety. And the Biden administration limited that definition to individuals who have committed aggravated felonies. So aggravated felonies usually deal with serious criminal activity. For example, murder, kidnapping, violent crimes, theft of large amounts of or sums of money, or fraud involving amounts of over $10,000, among other categories. But so aggravated felonies, then criminal street gangs. So think of individuals from Minas and El Salvador that have little cliques here in the United States. Those will always remain a priority for deportation. And organized crime, right? So also similar to the Minas and El Salvador, any criminal enterprise that is organized to break the law in a local or international way. All right, folks. So through the use of prosecutorial discretion, so the main question is, well, so how does PD or prosecutorial discretion help me? Well, we can do a lot of things here. And there's a lot of factors to consider and bear in mind when requesting it. And I'm going to cover a few. By the way, there's a memorandum published by the Department of Homeland Security establishing all the factors and procedures to follow or consider in granting or requesting prosecutorial discretion, that is dated May 28th of 2021. But some of the things we can do is to request that the government files or cancels a notice to appear. Importantly, and here's a parentheses. In the presentation, I'm including a copy of a notice to appear. So what is a notice to appear? A notice to appear is a document. This document is a sample created by the Department of Homeland Security, and which it lists a few things. So first, it needs to identify the person, right? So Here it should go the name of the individual, the case number, and then they allege a few things, right? So you're either a person arriving at a U.S. port of entry, either land or sea or by air, or you're in the United States without documentation, or you had documentations but you committed an offense that makes you deportable. So that's the first field. Then there's some allegations that the Department of Homeland Security issues against you, and then they need to say what it is specifically. And then there's a charge of either removability or deportation, in which the government says, well, this is the reason that we can seek to remove you or deport you, and this is the citation of the law. And then at the very bottom, it also has to have a date and time, or it's not an effective notice to appear. So in this example, we have a placeholder. It says a date to be set. In a recent Supreme Court decision, Nis Chavez, the Supreme Court found that unless it contains all the information required under the law, the notice to appear is ineffective to stop the time that you need to accrue to request certain benefits in immigration. But small parentheses there. That's why we show you the notice to appear so you can see what it is. But in essence, notice to appear is a document prepared by the government alleging why they're seeking to deport you. So now, through PD, Prosecutorial Discretion, we can seek to, as a government, to not file a notice to appear, or maybe they give you one, but ask them not to file it with the immigration court. Or in some cases, and most notably, most commonly, we see these cases where we actually request that an NTA is filed when we have a very strong case and very strong humanitarian reasons to seek it. So think of parents who have very sick children and that they need to become lawful residents of the United States. So that's one thing we can do with PD. Here's another thing, and it's amazing. We, like I said at the beginning, we had a decision yesterday by the Attorney General of the United States that makes administrative closure possible again. In, I think, 2 or 3 jurisdictions, administrative closure was still eligible, but in most of the United States, it wasn't. There was a decision by the former Attorney General, Jeff Sessions, saying that this tool that we've used for 30 years was illegal, that the immigration judges had no authority to use this tool, even though they have been doing it for over 30 years. Thankfully, we had a decision yesterday saying, well, that's nonsense. We're going to vacate that decision, pretty much throw it away. And while we wait for regulations, making it clear that the immigration judges can administratively close proceedings, we're going to allow people to request it again as it used to be. More on this in a few minutes when we start that topic. But let me tell you, so why would you want to admin close your case? Well, let's say you end up in proceedings and you have another relief available. For example, you are married to a U.S. citizen and you can file a family petition and you don't have any other disqualifying activity that would prevent you from filing a waiver. So instead of fighting your case in immigration court, usually seeking non-cancellation of removal or asylum or withholding of removal, which is incredibly difficult to get. I cannot stress how hard it is to get. So instead of pursuing that, what you will do is just admin close, file a waiver, then come back, reopen it, close proceedings, and you finish the process of getting your green card through a consular post abroad, and then you return lawfully to the U.S. Other reasons is that, for example, you are the beneficiary of a filed U visa, but it's 8-10 years in the future that you're going to get the U visa. So instead of having to postpone the case indefinitely, we can just admin close. And once you get that visa or that benefit, you can come back and terminate proceedings. So that is back in play. I'm very excited about this. Many of our clients are benefiting from this. So that's a great thing. Another thing we can do is dismissing proceedings. So here, I cannot stress how big of a difference this is from the previous administration. So the policy from the previous administration was that anyone who can be deported should be deported and will be deported, period. There's really not much use of discretion. We couldn't even talk to the ICE attorneys anymore, send emails. They wouldn't even reply or pick up the phone. Now, if we present a good case, and we're going to talk about the how it is that we present these cases for PD in just a moment. But now we can approach the government and say, hey, you know what? We have a very good case. This person can likely fix her papers, working with Citizenship and Immigration Services, or, this person is a lawful permanent resident of many years. He doesn't really have a very negative criminal record. Let's go ahead and close proceedings. Now, this is a very important tool because there's 1.3 million cases currently pending in the United States in immigration courts. So the government has to figure out a way of decreasing that number. Now, they're trying to hire more immigration attorneys, but just the sheer volume of cases is absurd. So this is one of those tools that they're doing. PD is perfect for that. And well, I might as well talk about the factors that should be considered in presenting a prosecutorial discretion case. So there's several, and that were listed in the memorandum, but these are not mutually exclusive. We can also come up with other things that are not listed. So, but things that are weigh heavily is length of residence of the United States. So if you've been living in the United States for a long time, that plays to your favor. Also, if you serve the United States military, or you have a relative that is serving the United States military, that is also looked favorably. Family and community ties. So if you have children, or if you have parents or siblings, or you are really involving your community, right? So if you're, one of these people that like to march and organize and drive people to the polls, that is looked up as something favorable. Also, how you arrive to the United States. It's not the same when people arrive to the U.S. when they're in their mid-20s to work versus when you were brought to the United States as a baby, and you had no decision at that. So that is important. Also, your immigration history. If you have multiple removal orders, that's going to be negative, right? But if you've never had any incidents with immigration authorities, that will likely be a positive factor. Also, your work history, right? If you're, an independent individual. And regarding work history, it's always important when we have work history, the filing of taxes. So if you have a long history of work in the United States, the government very likely is going to ask to look at your taxes. And if you don't have anything to show, they're going to ask, well, why didn't you file taxes? Because it's everyone's responsibility, regardless of immigration status, to file your taxes in the U.S. And here's some other things that they will consider. A person's education or pursuit of education, whether a person is a victim of a crime or witness to a crime, and whether there's any immigration relief available and some other things. So whether you have DACA, VAWA, a U visa pending, or a family petition that would be approved pretty soon. So all these things are considered, among other things. They also have humanitarian considerations, for example, your health, your age, whether you're pregnant, or whether you're the primary caregiver for a person that's seriously ill. Now, those are the positive factors. Here are the negative factors, right? So recent arrival to the United States, if you have criminal history. So if you do have a criminal conviction, they're not only looking at whether you have something, it's, well, how serious was the offense and how long ago was it? And is it the only one, or do you have a long rap sheet? So it's very important that if you do have a criminal history, check with a competent immigration law attorney to see if it's even worth trying to find your way out of immigration proceedings, or if you just need to focus on what you're doing or not doing. All right, so those are some of the factors to consider in granting prosecutorial discretion. Again, these are not but the only factors that can be considered, but these are the main ones listed by the government. So what else can we do with prosecutorial discretion? We can ask to not pursue appeal. So for example, if you had a very weak asylum case, but you had a very understanding judge, and they understood the hardship that you would face should you be deported, or if your case was denied, but it was a weak case, it was granted, we can now persuade ICE to not file appeal. So, that works out for everyone because the justice is served. Some other things, we can now, again, ask the government to join in motions to grant relief. So whether, it's cancellation of removal or adjustment of status in court, or to reopen, or, send proceedings back to the immigration court. So it's not that the government completely or stopped doing this completely, the previous administration, but it was incredibly hard to get them to agree on anything like this. So it would have to be pretty much a perfect case for them to agree. We're able to do it on a few occasions, but nothing like the Obama years. Thankfully, this is a return to normalcy, and hopefully we can get the cases in immigration court down. An important thing we can also do now is stipulating to certain things. So this is a huge help, or a very useful tool, because in some cases, we might have a very a very strong case in some aspects, but the legal standard that we got to meet is so difficult, so challenging, that most judges will say no to it. But now we can stipulate to this. Or maybe we have cases that are 50-50. We can stipulate to something, and then make that case a lot stronger in court. So this is a very useful tool, something that pretty much all my cases and likely any case in immigration court will benefit from. And there's other tools we can do. There's not limit or other things we can do. This is not the only use that we can use this tool or implement this tool at. So it really depends on your situation. And then, if we can think outside the box, we can probably get ICE to agree on some things if we present a strong case. All right, folks. So more on administrative closures. So again, one of the best news of the month, I would say, was this decision. So let me recap what happened here. So for about 30 years, the immigration judges, since the mid-'80s, were doing something known as administrative closing. So what this does is that it doesn't end the case completely, but it takes it off the active docket, the active case list that the immigration court handles, and sets them aside while something else is happening, right? So this was used for about 30 years. In the 2010s, we started defining certain standards, and we started defining how to implement them and when to request it. So we had a series of factors to go through, even when the government would oppose your motions. So, we had a working standard until 2018. Now, the Attorney General, Jeff Sessions, came in with a decision of Castro Tum, and it said that there was no authority in the regulations or by statute to allow immigration judges to administratively close proceedings. And therefore, all those cases that had been closed under the Obama administration were placed in the active list cases. So that, again, increased the docket nationwide by several hundred thousands of cases. And, they remain pending. Well, yesterday, the Attorney General Garland issued the decision of matter of Cruz Valdez. In Cruz Valdez, a very typical situation, right? So Mr. Cruz Valdez went to the immigration court and said, well, I would like my case to be administratively closed because I'm married to a U.S. citizen. She filed a family petition. It was approved. I don't have any disqualifying criminal activity. But the only thing that's preventing me from filing the waiver that I need to complete my process abroad is that I have open removal proceedings right now against me. So the immigration judge was told Mr. Cruz Valdez that, no, sir, we can't do that. We are preempted by Castro Tum, and it took away our authority to do this. Then Mr. Cruz Valdez appealed to the Board of Immigration Appeals, and the BIA said the same thing. You know, Castro Tum controls. We can't really do anything about this. So the Attorney General Garland, took this case, certified to himself, and said, no, we're going to grant this case. We have this authority. Castro Tum was incorrectly decided, and we're going to overrule it completely. And by the way, we're waiting on regulations that make this clear, that we can admin close cases to manage the immigration court's docket. So that was the great news. So what does this mean on your case? So let's say, you know, you ended up in deportation proceedings because, you know, you committed a DWI, let's say, or, you know, some minor infraction, you know, non-aggravated felony offense or anything. And that does not make you inadmissible. All right. So you end up in proceedings. You're married to a U.S. citizen, or you have a U.S. citizen child over 21, and one of your parents is a U.S. citizen or lawful permanent resident, or your spouse is. So you file the family petition, but you're in immigration court. Now, it used to be that without the immigration proceedings, you could just file the waiver, the I-601A waiver. That's why I'm putting it right there so you can see it. That's what I mean. So now you can admin close. Now the regulations for the waiver allow you to file the waiver if you're in immigration court, but only if your case was administratively closed. So that was the technicality that was missing. So now, thanks to the decision of Cruz Valdez, we can do that again. In what other contexts can we do admin closings? So again, if you have a pending U visa case, or if you have a special immigrant juvenile visa case pending, and you're just waiting for the visa to become available. So, you know, this is a great tool. The bottom line is this, and we're gonna open up the space for some questions. I'm gonna stop sharing my screen and end the presentation, but let me give you. Okay, so but the bottom line is this, right? Now we can approach the government and ask them to join us on something that would pursue justice, right? So now we can focus more on what is the just result and not in, you know, the government is trying to deport me, period, right? So we're going back to a more reasonable, more equitable, more just system, which is a very welcome change. If you have a complicated case, if you have a criminal conviction, something like that, talk to a competent lawyer that can help you navigate the system. But yeah, so if there's any questions, actually, you know what? We're going to address a few questions right now that I've received regarding PD this week in anticipation to this meeting. So the first question was, can prosecutorial discretion help me if I have DACA? Of course it can help you. This is precisely a group or that's precisely the type of thing that PD is for. So if you have DACA, if you have some form of, well, DACA is not really status, but it's a protection. If you have that, you know, we can approach the government and say, you know what, let's end proceedings. There's no point in pursuing this. This is a good kid, has DACA. It's either in high school or completed high school and is doing this other things. So those are perfect cases for PD. Also cases, again, where we have a pending U visa and things of that nature. But yes, DACAs can definitely be helped. Okay, so here we have another one. We have an NTA against me was issued by the government after the asylum case, but it was never filed, and I'm still waiting for the court. Can PD help me? Absolutely. And that is one of those situations where, you know, we would be asking the government to actually file the NTA so we can get the ball going in some other ancillary matter. Each case is different. Each case presents a different set of facts and considerations. But in certain circumstances, yes, you do want to ask ICE to go ahead and file the NTA so you can do a series of other things. So maybe have your day in court to present your case, or maybe get the clock running again to get your work authorization permit. But okay, folks, so let's see if there's any questions right now. Okay, I see we have a few folks here joining us. All right. Well, again, my name is Jorge Molina, your immigration attorney. And if you have any questions, you can always call the office at 469-708-5800, or you can send us an email at info@jmolinalawfirm.com. It's been a pleasure being with you today, talking about this subject. And, I look forward in helping you in your cases if we can. Bye-bye.